There was an initial list, my lord, which was circulated by the nodal council in which my name was included. And that seems to be, my lord, omitted from the revised list. I've communicated with the nodal council. I'm only seeking, my lord, a 10-minute time. Not more than that.
Why are you appearing?
In support of the petitioners, my lord. In support of the petitioners in the main case. For a gay activist, my lord. From Bombay. No, my lord, I'm only seeking a very short time merely because the theoretical aspects, my lord, of anti-discrimination law, in particular, my lord, the theory of disgust by Mehta, only to elaborate on that, I'm only seeking 10.
Anybody who's an activist should come and address this court?
No, my lord, only because...
It can't work out like that.
Not like this.
Now, your lordship's PDF...
Request, my lord, only 10 minutes of time, my lord, because this court, my lord, is not usually it does not respect arguments of counsels.
Look, you're also not ignorant. I've read Mehta Nazbom extensively, and I still continue to read Mehta. That's after my day's deed is done in the court. This is what we sit down and read to get some sanity in our mind also at the end of the day. Mehta Nazbom, do you have to keep on interrupting by the minute over here that I'm appearing for a gay activist? I want to show you Mehta Nazbom. Of course, just give us a note. We'll read it.
My lords,
it's a matter of joy for us to read. It's a matter of joy for us. This is
PDF 1180 minutes.
Singhvi, this was a case where the Act squarely applied to unmarried relationships.
Yes.
And the principle was that if you're unmarried, if the Act applies to unmarried relationships between heterosexuals,
yes,
there is no basis to exclude unmarried relationships among homosexuals.
It is the second last formulation of the lordship sentence which I am concerned about, that when you have a particular paradigm applying to a heterosexual group, your lordship, absent something very special, will find it discriminatory not to apply to
others. Baroness Hale uses the expression marriage-like relationships.
Yes.
So these are not marital relationships, marriage-like relationships of heterosexual couples who are in a stable relationship but who are not married. They said that therefore, if you are extending protection to heterosexual couples who are in a marriage-like relationship and therefore not married, there's no basis to deny it to homosexual couples who have a marriage-like relationship but who are not married.
I'm grateful, that's one. But the language of the paras I've read yesterday and today
maybe also very of extension. You're right.
And your lordship is not bound by these judgments. Your lordship will find persuasive value to the extent your lordship finds. Now I turn to that article, which according to me is one of the most well-written articles on interpretation. On reading down, reading up, what your lordship...
Which is that article now?
Treaty compliant, or in our case, constitution compliant reading. Constitution compliant reading. Kindly hand over. It's better to use the hard copy. I'll read only 3 sections, a few pages of it. Kindly hand over. Namely, the intention reasonably to be attributed to Parliament in enacting 3. So it's an objective test being brought in. Now, nor is the statute. A second thing which is not determinative is statutory text. And it is quite interesting and astonishing, though now in a constitutional context, American English courts are saying this. When we were brought up, it would be sacrilege to suggest this to an English court. Does not of itself make a convention compliant interpretation under 3 possible. So this is impossible, impossible. So your lordship's ultimate guide star is intention, no. Text, no. Parliamentary, overall purposive theological, no. But the ability to achieve a convention compliant result. So if it's a case where lordship finds the whole script has to be written, it has to go to the legislature.
This is how you make it consistent with the convention. The second is they abandon the purposive construction method.
And the textual and the intention based. Now if your lordships were to find
diametrically,
if there's a prohibition, I would say in fairness the answer would be no. If the language is diametrically opposite. When your lordship puts that question, I am answering it saying that diametrically opposite must mean prohibition.
The prohibition, that could be.
Prohibition.
We are looking.
Answer has to be no. I am not here, to suggest your lordship that your lordship has a prohibition and your lordship is then overriding it on the basis of interpretation. Then your lordship may be able to override it for some second argument. It's not the only answer. Second answer is your lordship as not constitutionally compliant. There are 2 ways of looking at this. One is that we challenge it on the ground of unconstitutionality, as we are doing the notice and objection provision to which I have just returned. Your lordship will then apply that test. The first test my lord Justice Narsama is asking me is intra-legislation. To that the answer would be if there is a prohibition and I still ask you to only interpret. Your lordship
how can we confine to that concept that if there is a prohibition, then only we say that it should go back to the legislative drawing board. Because
no, if it is not constitutionally compliant on the larger challenge, no, your lordship can strike it down.
Because let me complete. We are focusing our gaze on the only provision. In Gaidan, it was possible. Gaidan, the question was simple. And also, Gaidan was not essentially concerned with matrimony. Essentially, it was concerned with protecting tenants and whatever was the consequence if one of them who was living in a relationship died. So therefore, it was possible to not even go into the internal mechanics of the concerned enactment. Here, perforce, whether you like it or not, we will have to insert ourselves into the mechanics of...
Therefore, two things. Ghedan, the underlying, although the issue was Rent Act, the underlying thrust was found by all 5 judges to mean that you cannot discriminate between heterosexual couples versus homosexual couples in the interpretation of that act. Number 2, the question would be if your lordship found that SMA, the underlying thrust, is not this, or the SMA precludes that underlying thrust, then your lordship would go one way. If your lordship, however, to find that the underlying thrust of SMA does not exclude, and that's the heart of the answer to my lord's query, does not preclude or exclude a same-sex couple, that follows. Therefore, that choice ultimately follows the...
If presented the way Gaidan is presented, we have no difficulty. But if you take the steps in Gaidan, which is the internal sense of the enactment, then we will necessarily have to go into
the two different acts. Lordship, naturally, this is Gaidan is something else, this is something else.
Then
I'm only on the approach.
The route which we may have to take is something else.
Well, I'm only giving your lordships a approach to interpretation,
yes, right,
which should comment your lordship, obviously in a different context.
It's a very novel approach.
Novel approach and a different context.
Said that here, you're really leading us on the path of statutory interpretation.
That's true.
Statutory interpretation, not based on text, not based on intention, not based on original intention, not based on purposive teleological intention.
You're really asking us to read into the statute the expression spouses for really man and woman.
So does the underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct?
Because your principal premise is that when the legislation was enacted in 1954, the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage.
Absolutely.
Right? And not
categories.
You are giving Parliament was intending to provide an avenue to people beyond your religious, the religious governance of marriage, so to speak.
Yeah. There was also an aspect of endogamy.
Yeah.
Yes.
There was an aspect of endogamy which we cannot ignore.
So
it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to be very special category.
After 1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable relationship.
Because you go back and say,
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law. And surely that law is capable of being broadly read according to you, so as to take into account more stable relationships.
Let me put it bluntly. Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
That makes no difference.
The way which you are perhaps propounding is, this provided a framework, but that framework is of the concept of marriage. The concept of marriage transcends as a contemporary understanding to...
It's an evolving dynamic concept.
Comprehend an evolving idea.
Very dynamic concept.
So used in a constitutional sense, it only provides a framework. And that framework is broad enough to, assimilate later developments.
I don't want to
the existing.
I don't want to sound well as that is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Gaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new statutory scheme.
Yeah, exactly. Would the court be rewriting the entirety of the statute? Would the court really be making policy choices which is for the legislature to make? So long as we don't straddle that line which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The first test was enough.
The impact of Gaidan is to liberate the court from the very, very traditional approach of looking at everything as a matter of statutory interpretation. Therefore, purposive interpretation also falls back on interpretation of that statute and the language of that statute.
That is important, Malas. That teleologic and purposive also, which is supposed to be in advance, falls back.
I'll play a little bit of a spoiler. Gaidan provided the framework for the introduction of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years for these to be recognized as marriages. So that too is an aspect which we will have to keep somewhere in mind.
Absolutely, but your lordship, that's the difference. It's a holistic thing your lordship keeps in mind. Ultimately, the feel of the case is only your lordship will. That is, nobody can be identical. Nobody is saying that.
I'm sure if you go to Gaidan and if you follow it up, there could be other cases which have followed that.
So I've now time. I've done this.
Dr. Singhvi, looking at India constitutionally and socially as well, we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage-like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation. Once we have made that, we have crossed that bridge, then the next question is as to whether our statute can therefore recognize not just marriage-like relationships, but relationships in the relation.
On the contrary, I started by saying it's a logical move in the same direction. It is in fact little done, vast undone. Your lordship is now getting to cover that territory, because to merely decriminalize is one category. Otherwise, it does, in an actual daily sense, remain a shell.
Requires us to redefine perhaps the evolving notion of marriage, because is the existence of two spouses who belong to a binary gender necessary, or the requirement for a relationship of marriage? Or has our law now progressed sufficiently to contemplate that the existence of binary genders may be, but is not necessary for your definition of marriage?
And Malas, to that comes in the intersection of the Article 14. You in your counter and everywhere else are underlining immeasurably the vital importance of marriage, to which I bow down. But that vital importance of marriage is restricted to one category.
Expanding that definition, are we then trenching upon that area which Gaidan excludes to the judges?
That is, Malas, in case your lordship has got to stitch a whole cloth, which only a statute can do. That ultimately will be a lordship's call. I don't think at all. Which now, Joshua will just note on the side, para 44 has some other cases similar to Gaidan. I'll not read them. I don't have time to read them. Para 44 of my submissions.